Hello and welcome to the viewers of Law and Life. This is Shashank Mishra as a host, present with the renowned senior advocate of Supreme Court of India, Subodh Markandeji. The senior counsel in this channel discusses on various legal issues that are happening in India, statutes, and development of legal history with its political aspects and such other topics. Likewise, today we will be discussing on the topic real need for effective execution of Supreme Court judgment. I was outraged to learn that the FIR was still being registered under Section 66A of the Information Technology Act, though it was struck down way back in 2015 in Red Shreya Singhal's case.
Yes, yesterday I also noticed that one such case, miscellaneous petition number 902 of 2021, filed by the People's Union of Civil Liberties versus Union of India, came up for hearing before the bench consisting of the Chief Justice of India and Justice S. Ravindra Bhatt. The applicant therein was perhaps petitioner in writ petition criminal number 199 of 2013, which was disposed of by the Supreme Court with the batch of Shreya Singhal's case. It seems the applicant, uh, People's Union of Civil Liberties, took the assistance of another organization called Internet Freedom Foundation and raised the following issues. A. Whether the judgment in Shreya Singhal has been complied with. B. Whether steps taken by the Union of India are adequate. C. What steps need to be taken for effective implementation of the judgment in Shreya Singhal to avoid wrongful investigation and prosecution. And D. What steps should be taken by the Ministry of Information Technology to ensure effective implementation of that judgment for ensuring that judgments in important cases touching protection of legal and constitutional rights of the citizen are effectively implemented. Very important questions have been raised in this miscellaneous petition.
So, sir, what is the way out?
So, here, what the court did was the bench noted with serious concern that despite the pronouncement of the Supreme Court of India declaring Section 66A of the Information Technology Act to be unconstitutional, offences under Section 66A are still being considered. That is, I think the complaint is that the FIRs under that section are still being registered. The court therefore directed the Council for Union of India to get in touch with the chief secretaries of various states where offences are still being registered to impress upon those states to take remedial measures as soon as possible. The council was also given liberty to ask the chief secretaries to furnish information in that regard and to complete such exercise within 3 weeks. The matter will again come up for hearing after 3 weeks.
So what is your considered view is long-term solution?
Yes, Shashank, you are right. This is uh, some kind of working arrangement. That order of yesterday is only working kind of arrangement. A permanent solution has to be found for this very serious problem.
Yes, sir.
Recall that in our episode number 32, we have discussed the inefficacy of the present remedies to enforce the judgments of the Supreme Court of India and have suggested some remedies like Parliament should make a law, which it has not done since the Constitution came into force. Or in the alternative, the Supreme Court itself may frame rules and in exercise of its own power under Article 145. But some these are more serious problems. Those were all civil cases. Here now, FIR is being registered, so naturally it follows that the persons against whom the FIR is filed will be arrested, investigation will be undertaken. So all this in regard to something, some law which has already been declared unconstitutional. So the whole proceedings are totally illegal and unconstitutional pursuant to those FIRs. So this is a more serious matter. Therefore, uh, I think someday we will have a larger discussion. But what immediately occurs to me is that the Parliament should, it's time, high time that Parliament, exercises its power, its plenary power and its primary power to enact a law with regard to the implementation of the judgments and decrees and writs of the Supreme Court. In this regard, we can also see Articles 138, 139, 140, 141, 142. All those powers with, in regard to which Parliament alone has power, they should all be activated because the citizens must be uh, made immune from such wholly illegal prosecutions. So it's a very serious matter, and I think it's time. Yeah. But I may suggest that Supreme Court itself, in exercise of its power under Article 145 to frame rules, a chapter can be included in the Supreme Court rules in this regard. Just like there is a chapter in regard to the contempt matters
Yes,
before
sir.
the Supreme Court, where it is alleged that the contempt of Supreme Court itself has been committed. So likewise, a chapter can be added in regard to all these matters. Because yes, it's true that so far as, particularly this need has been felt for a very long time in regard to service cases. And what happens is that, we go to Supreme Court in contempt matters. Now, contempt is not something which the civil servant likes. Contempt, the person who has to, obey that order. I want
Yes, sir.
obedience, contempt. Not, I don't want to punish. I don't want to send him to jail. All that I want is that if there is pension, it should be paid. If there are areas, those should be paid. If there is some other uh, remedy which I have sought, some other relief that should be given. I don't want to send him to jail. Therefore, this can be ensured only if the Parliament passes the law or Supreme Court itself, uh, in exercise of its own power under Article 145, which is undoubtedly it has,
Mhm.
to frame rules in that regard.
Yes, sir. We're looking forward to Parliament to form a new law. Thank you, sir, for telling and informing all about it, sir.
Thank you
Yes, sir.
for hosting a video on a very, very important topic for citizens. And yes, when in Shreya Singh's case, when that section 66A of the Information Technology Act has been struck down, there is the question of registering FIR in respect of that. Then whole exercise of going to Supreme Court is all nullified.
Yes, sir.
So there should be some provision added, to prohibit such things. And if someone has some FIR has been registered under some person, some citizen or even non-citizen, then we should be compensated for uh, a totally illegal investigation. Thank you.
Yes, sir.